This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why even a brilliant doctor who lies on an application will find her policy rescinded. And because this brilliant doctor refused to recognize she was deceived by an employee, even though she had many facts to prove it, misrepresented facts on an application for insurance, and that false statement on the application resulted in rescission of her insurance policy. Former patients of Pediatric Partners for Attention and Learning, Inc., sued the clinic and its founder, Dr. Joni Johnson, in state court after learning that the clinic's in-house psychologist, Sharonda Avery, who treated them, was actually not a psychologist at all. The insurer sued to confirm rescission because the application Dr. Johnson had filed contained false statements. In a case entitled Medical Mutual versus Cathy, Gnik individually and his mother and next friend of N.A., a minor, et al., filed in the United States District Court for the Fourth Circuit, which decided the case on February 16, 2024. The decision was based upon the following facts. Pediatric Partners and Dr. Johnson asked their professional liability insurance carrier, Medical Mutual Insurance Company of North Carolina, to defend and indemnify them in the lawsuits. In response, Medical Mutual brought a declaratory judgment action in federal court, arguing that it could rescind the policy covering Pediatric Partners and Dr. Johnson because Dr. Johnson made material misstatements in her insurance applications. The district court agreed and granted Medical Mutual's motion for summary judgment. In 2012, Dr. Johnson had founded Pediatric Partners as a multidisciplinary clinic offering medical, behavioral, and cognitive services to children and adults in Virginia. That year, Dr. Johnson hired Sharonda Avery as an educational advocate, a position that did not require a license. In 2013, Avery approached Dr. Johnson about becoming a Pediatric Partners in-house psychologist, claiming she had recently obtained a Ph.D. in general psychology and would soon earn a PsyD in clinical psychology. However, Avery was lying. Before Avery assumed her new role, Dr. Johnson asked Avery for proof of her license to practice psychology, and when Dr. Johnson asked for proof of that license, Avery did not provide any. Avery's inability to produce a license did not stop her, and although dishonest, Avery was resourceful. She provided Dr. Johnson with fake Ph.D. and PsyD diplomas. This apparently satisfied Dr. Johnson, so Avery began administering cognitive testing to patients while holding herself out as a psychologist. In the spring of 2014, the Virginia Department of Health Professions, VDHP, received a complaint that Avery was practicing psychology without a license. A VDHP investigator visited Pediatric Partners and spoke with Dr. Johnson about the complaint. After Avery's promotion, Avery told Dr. Johnson without elaboration that she did not think she could become permanently licensed. Even so, Dr. Johnson permitted Avery to continue providing testing and therapy services. Later in 2017, while Avery was working part-time at Pediatric Partners, Dr. Johnson sought professional liability coverage from Medical Mutual. Dr. Johnson completed an entity professional liability application and separately a medical practitioner's professional liability application. The entity application included the question, quote, Has the applicant or any of its employees ever been the subject of disciplinary investigative proceedings or reprimand by a governmental or administrative agency, hospital, or professional association? Close quote. Despite knowing about the VDHP inquiry, Dr. Johnson answered the question no. Medical Mutual issued a professional liability policy to Dr. Johnson and Pediatric Partners for a period of September 1, 2017 to September 1, 2018, but the policy had a retroactive effective date of September 1, 2012, meaning it covered claims based on conduct going back to that date. In September of 2017, Dr. Johnson terminated Avery, not because of Avery's fraud, but due to her increasing unavailability. Dr. Johnson claims she only learned of Avery's fraud after Avery left Pediatric Partners. Dr. Johnson filed claims with Medical Mutual based on 2 complaints made to the VDHP against her. Whatever the details, there was no dispute that those complaints related to Avery's fraud. Still, Medical Mutual renewed the policy, albeit at a higher premium, after identifying the complaints in the policy renewal worksheet for a period of September 1, 2018 to 2019. Authorities arrested Avery in 2019 on multiple state charges stemming from her fraudulent conduct, and in 2020 she was convicted. The district court granted Medical Mutual's summary judgment motion, concluding that Medical Mutual had clearly proven that Dr. Johnson's answer to the disciplinary investigative proceedings question was a material misrepresentation. The Virginia Code permits an insurer to rescind an insurance policy if the insured made a material misstatement in the policy application. Dr. Johnson's subjective knowledge of the falsity of her representation is irrelevant under Virginia law unless an insured qualified her statements as being to the best of her knowledge or with some similar limitation. Clear proof of mere falsity of the statements is sufficient to support a rescission. Courts in Virginia apply traditional principles of contract interpretation when reviewing insurance policies, and when a policy term is unambiguous, a court will apply its plain meaning, considering the entire phrase and its contents. Disciplinary investigative proceedings is not ambiguous. Medical Mutual contended that the affidavits of 2 of its underwriters carried the burden of clearly proving the materiality of Dr. Johnson's misstatement. Both underwriters indicated that had Dr. Johnson accurately represented that one of her employees had been the subject of a disciplinary investigative proceeding, Medical Mutual would have learned of the 2014 investigation into Avery and refused to issue the policy. Based on the underwriter's affidavits and the renewal worksheet, the court found that Dr. Johnson's misstatement was material. Medical Mutual has clearly proven that it would have issued the policy at an increased premium, if at all, had Dr. Johnson accurately represented that Avery had been the subject of a disciplinary investigative proceeding. Accordingly, there was no genuine dispute of material fact that Dr. Johnson made a material misstatement in her policy applications, and rescission was proper, and the judgment was affirmed. In my opinion, insurance is a business of utmost good faith, where neither party to the contract of insurance will do anything to prevent the other from receiving the benefits of the contract. Dr. Johnson, in bad faith and with knowledge, lied to Medical Mutual to obtain insurance and ignored the fact that she knew Avery was not licensed, was not a college graduate, let alone a holder of a Ph.D. Rescission is an equitable remedy where the court concludes it would not be fair to require an insurer to indemnify an insured who obtained the policy by misrepresentation or concealment of material facts. And that's exactly what they did. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you can subscribe to the blog and you'll be advised of blog postings, usually 5, sometimes 6 a week. You can also subscribe to the videos on YouTube and rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in obtaining further and detailed information about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.